What we're doing today, we're going to talk a little bit about what is the company's constitution, continue the discussion that we started last week on what is separate corporate personality, and we're going to investigate a little how companies work, because it's great to say that something has got separate personality and is a different person in the eyes of the law. However, it lacks little hands. The company is even worse than the dinosaurs, because not only it has little hands, it has no hands at all. So how do you expect a company to be able to do stuff when it's not represented in the physical domain? What we're talking today, overview of advantages and disadvantages of incorporation, and we talk about the company's constitution and how companies perform a variety of acts. Let's discuss a little bit our friend Salomon. Now, we touched upon this last week. I really like the guy. Salomon is the case from 1896 is when it made it to the House of Lords. Our friend Salomon here heard about the idea of as a new entity, heard the idea about limited liability and all these features that the new company has, and he thought, this sounds a great idea, let's do this. Gets all his family members together, because at the time you needed a number of subscribers to be able to start a company. It wasn't possible to have a single member company like we do now. So he gets all the kind of wife and kids and etc. They all sign on the dotted line. They create the company. But creating the company doesn't mean that the company is instantly the business. So the business belonged to Salomon. He was the one who was running it. So he needed somehow to pass the business to the company, right? But how is the company going to purchase the business? Because the business is not simply a concept. It was a store, they had assets, they had stock, they had all sorts of things. So where did the company get the money to purchase the business? Salomon made a loan to the company. So originally there was some money that went in order to establish the company, because they needed to be the original purchasers of the shares and so on. But this was enough to set it up, but it was not enough for it to do any actual commercial actions. So Salomon makes a loan to the company. The company uses that loan in order to purchase the business from Salomon's family. But effectively, it's like Salomon took money out of one pocket and put it in the other. Kind of looks like that, right? So Salomon makes the company, gives a loan to the company. To ensure that he gets repaid, he utilizes one of the legal mechanisms that we have to get some security for the loan, as it's called. So he registers a charge over some company assets. Now, this is a process that we're going to see later on in the module. Effectively, what you do is that you say, if this company goes bust, then I am the first person to come in and lay claim on this that is a valuable asset. So this offers you, you're first in line, it offers you access to something valuable, so you got a much higher chance of being repaid if the place has gone bust than everybody else. Right? He gives the loan, gets security of that loan, transfers the business to the company, so kind of gives him back the money because it purchased the business. They run happily for a little bit, but then they get into trouble. Now, this looks a little bit fishy, but nobody suggests that they did this in order for the company to fail, right? This happened independently. So they ran with this for a little bit, but then the company went into trouble, and eventually they could not service their debts, they could not pay their suppliers and so on, and they went bust. Salomon is a shareholder. You cannot go after shareholders because that's the whole point of limited liability. Can you go after him in some other capacity? Well, no, not really, because from the moment that he sold the business to the company, he might have been a director of the business, but directors are not personally liable for the debts. As a shareholder, you're not personally liable for the debts. But funny enough, he was able to recoup the loan that he made to the company because he was secured and he was first in line in case something goes wrong. Everybody else who went to be paid afterwards, the company told them, I'm sorry guys, but we've gone insolvent. We don't actually have enough money to satisfy everybody, so some of you are going to have to walk away with nothing or with a proportion of what you're owed. Everybody else who was waiting and didn't get the money, they thought, hang on a second, how come we've always been doing business with that guy? We're still doing business with that guy. But somehow the company has failed. He walks away. He doesn't lose any money. We're the ones left holding the bag. And this cannot be possibly what the law is about, because effectively the process of incorporation allowed this guy a way out of his responsibilities. The business was, well, he was pocketing the money and he was participating in the success of the business. But now that the company has gone bust, he loses nothing. He walks away. We're the ones left unpaid. So this didn't look right. And if you kind of look at it from the outside, it does look a little bit like a scam, doesn't it? It does look like a scam. It goes to the court has a look at this at first instance, and they're thinking, meh, I don't know, this looks a bit fishy. It goes to the Court of Appeal, the Court of Appeal has another look at this. They're thinking, in fact, we're not sure, this doesn't look right. So this looks like the use of a new structure in order to evade responsibilities. So there's something going wrong here. It's not possible that they intended. They go to the House of Lords. The House of Lords has a good look into this. And they come back and say, you know what? This guy did exactly what he was meant to do. The law gives you the ability to create a limited company. He did that. The law gives you the ability to get security on your loans. He did that as well. He hasn't done anything that is improper. Everything that he did was perfectly legal. Now, the consequence of it is a little bit unpleasant. It didn't happen, they couldn't find any intent. Of course, if the court found that the guy knew that the business is failing and he did this in order to protect himself, then it would be fraud, it would be something else entirely. But since there was no evidence that any of this was fraudulent, this was just an unfortunate expression of the rules, but Salomon had done nothing wrong in setting up a company and arranging his business affairs in a way that was prescribed by law. And the conclusion of the court is, well, you don't like it, ain't my problem, go lobby your MPs to change the law. If you think that this is a law that leads to unfortunate consequences, this is not a matter for the courts, this is a matter for the legislator to change the law and for something else. You could argue that this is fine, and this is what happens, and it didn't work then, but it's worked in other circumstances, or sometimes you're lucky, sometimes you're unlucky. The recognition of this is how the system operates and can have these distinct consequences is fine so long as you know about it. Because if you know about it, then you got ways that you can arrange your things in order to protect yourself. What could a creditor do to protect themselves knowing that this is the consequence of limited liability? You can do what Salomon did. You can take security over your loans. Or if you're doing business with a company and you are supplying them with goods, but the invoices get paid at the end of the month, so there's a difference in time between them having the products and you receiving your payment, get something. There are contractual mechanisms, there are other mechanisms to get some security over this. So if you know that this could happen to you, there's something you can do to protect it, to protect yourself. If you're making a loan to the company, you need to factor in your risk calculation the possibility that the company is going to go bust. What do you do if you're lending money to somebody that you think might go bust? You charge them a higher interest rate. So what happens is the cost of arranging the loan is a reflection of, if you're dealing with somebody that's never going to go bust, then you give them low interest. You get very low interest rates or even negative. If you're dealing with somebody who could go bust, then higher amount of interest in order to lend them money. If you're dealing with a company that is unlimited and has got wealthy backers, then you don't care. You can give them a loan, you know that somebody's going to return your money somehow. If you're dealing with a business protected from limited liability, then you will charge a higher interest in your loan to accommodate the chance of loss. I mean, there's a whole financial industry based on the idea of risk assessment and how much return can you get depending on how likely it is that you're going to be repaid. And if anything, people are looking for things that are slightly riskier to invest because that's how you can get a good return on your investment. If what you're investing is 100% safe, then you're effectively parking your money somewhere you don't expect to make a return. Invest in something slightly riskier, and then you're going to get some money extra at the end of the year. forward way to avoid all this, you could get a personal guarantee by the shareholders themselves. And that's why when we're having our initial discussions, if you have a business idea, should you do this? Should you establish a partnership? Should you establish a company? And people are thinking about a company, makes you look a little bit more legit maybe, or a bit more kind of business focused. If you go under a company name, you carry with it, the company carries with it the limitation of liability. If you go to the bank and say, I would like a loan for my new company, look how nice we are and we're all set up, the company is going to say, awesome, but because you got no track record, you got no profits, you got no assets, we're going to give the money to the company if you as a person give us a personal guarantee that if the company gets in trouble, you are going to pay what the company owes us. A personal guarantee is something that completely circumvents the idea of limited liability and solves this problem. If you are dealing with somebody like Salomon and you know him, but you're worried about the company that he just set up, get a personal guarantee from him. So a guarantee works as a secondary obligation. If the first person that has to leave does not, then the guarantor will pay on his behalf. What are, again, if we are to summarize this, what are the key features of a company? The separate personality and the limited liability, and our key reference point always are profit-making companies, and our baseline scenario is a private company limited by shares. What do you get with this private company limited by shares? The separate personality means that it can do stuff on its own, in its own name, it can own property, it can sue people, it can be sued by people. The fact that it's got shares, it means that these shares are transferable. The owners of the company can change. This is more difficult to do for a private limited company. It's a lot easier for a public limited company, but the transferability of shares is a key characteristic. And also a key characteristic of all this business with a company is that your management is distinct from the shareholders. The people who manage the company are called the directors of the company. The directors of the company are not necessarily its employees. So if you're a director of the company, you hold that office. It is an office with specific functions that are stated in the law. The consequence of not abiding by those functions can be both civil and criminal. If somebody asks you to become a director of a company, don't just say yes before you think about it, because it is a very significant burden and you can get yourself in prison if you don't do things properly. But the key thing is the people running it do not have to be the people owning it. In private limited company, it could be that one person has all those roles. If I set up myself as a consultancy, so I can offer, advice on company law to other people, now I'm allowed to set up this company on my own. I don't need a group of people. So I could set up Yannis Limited. I could be the 100% shareholder. All the shares are mine. I will also be the director of the company. I will also be the employee of the company. I'm the owner, but I am running the company and I'm also hiring myself out to other people to go and give advice. It's awesome. So I can hold all these roles that are distinct and have got distinct consequences, but I can still be the one person. If we're talking about a very small private limited company, nothing really changes from if you were running in your experience of it. It doesn't change if you were running it as a sole trader or like this, but the legal background and the legal wrapping around it does change. But if you imagine a bigger corporation where a bunch of people are involved, maybe some people invest some money, they expect to make a return, to make a profit in the long run, but they don't want to be involved in, they want to give the money at the beginning and then go home, do something else. These people could very nicely be the shareholders. The people who manage it and run it, they're the people who know what they're doing. So they've been put in those positions specifically because they're capable of running the business. These will be the directors. in all likelihood, they will also be hired as employees, so they make, a steady salary by being directors, or they could hire other people to be the management. But what you end up having in companies is a distinction between the people who are the shareholders and the people who are the managers. So this separation of ownership from control is something that can be good because the company is something larger than whomever is the shareholder today or tomorrow. It can accommodate a lot of different people who might be shareholders at different points in time. The company is a perpetual entity, so it could change shareholders and directors and all the rest of it and still survive in length of time. It could run for hundreds of years, but it can also cause issues. Because if you got this separation of ownership from control, how do you ensure that the people who run it in the interests of the people that own it? And there are tensions that arise in there. How is the management constrained and what are the objectives of management and how do you make sure that things are aligned to the best way possible? But we remember for the time being that separate personality, limited liability, separation of ownership is significant components of what we understand to be a corporation. What is it that makes the company and what are the key constituent legal bits that allow us to understand how it runs? Now, if we're looking at the company's constitution, and as this is called, like the legal framework that allows a company to work, we have to look at, obviously, sources of law. Sources of law, as usual, are primary and secondary legislation. You've got a lot of rules that are created by independent bodies that are recognized by statute. The stock market, for instance, is responsible for the regulation of public corporations that are listed in the stock market, but this is not a government body. So it's an independent body, yet the rules that they've got are binding for the companies that participate in their structure. So you have stuff done by law that apply to everybody, but you've also got stuff done by particular industry bodies like the stock market for the people that are participant in them. Obviously, you've got quite a lot of case law where the courts are interpreting things that are either present in statute or have come from the case law before. But crucially, you've got some things that are generated from the company itself. So the company's own constitution is a document that all the participants to the company sign at the beginning when a company is made, that is basically like the constitution for a state. It serves the same purpose. The company's constitution is primarily made out of its articles of association. So you're going to be hearing this concept very frequently. The articles of association are a long list of things that say how does the company do stuff? How does it arrange itself internally? Who decides on what and how and when? How does the company deal with outsiders? What is the process for appointing the directors? What is the process of meeting between the various bodies? What is the relationship between the shareholders in the general meeting when they all get together and the directors in the board of directors? So it will outline all the institutions that are involved in the company and the relationship between them and the relationship between those in the outside world. English law takes the view that the people in the best position to determine the company's affairs are the people who are in the company. So the regulation here is very permissive in allowing companies to come up with their own arrangements on how it is best for them to run their business. In other countries, you've got company law legislation that is actually more constraining into the types of arrangements as to the membership, for instance, of who is in the board of directors and who is represented there, and is it only the bosses or is it also the employees and all of that stuff. In the UK, you don't really have that, but what you have is treating the articles of association, this constituent document of the company, both as something that has got internal contractual significance, that people who sign it are bound by it, but it also has got effects on the outside. So the articles of association are both a contract between people but they're also a public document that demonstrates to the rest of the world how this company is supposed to be run. But the peculiarity is that the Articles of Association may be a contract between each individual shareholder with each other and the company with everybody else, but it is a public and publicly available document. You need to produce all this documentation, and then you submit this data to Companies House, that is where all this information is from companies, and they make it available. So you can actually go to the Companies House website and you can load for free quite a lot of stuff about how who are the members of a company, where the companies are, who are the people involved in it, and how are they supposed to do stuff. So you can you can get the Articles of Association and documents of that nature directly from Companies House and have a look. Because this is the price that you have to pay in a way for limited liability. Because you cannot tell people on the one hand that this company is a separate creature and is also protected with all these mechanisms, but then not to tell people anything about it. Private, real people in the physical domain, you can find stuff about them. Corporations that are people but in the virtual domain, they're obligated to disclose this information about themselves. It would be impossible to figure out what they are. There have been periods historically where people got involved in investments in things that they didn't know anything about, and that was rather problematic. I mean, ranging from investments at the end of the 19th century where companies were set up and they were selling shares and they wouldn't tell anybody what they're doing, but they would just advertise and say, participate in this super profitable investment overseas, and people would go, wow, that is a great idea. And you didn't know anything about the people involved or what they're doing or where they're doing it or how they're going to pay you back. This led to a lot of trouble. The law built in all these mandatory disclosures of information, and we're going to find a lot of those about corporate. So that's why all this documentation needs to be produced at the beginning when you're setting up a company, and then sent, uploaded for those institutions like Companies House that make it available to everybody else. So if you want to do business with a company, you're going to be able to check securely whether they exist and who are the people running it. Okay, does this company exist and where is it? You go to Companies House and it will say, this is the company, these are its directors, these are their home addresses. This is not going to tell you that this is a company that's actually wealthy or sufficient or able to pay for the tickets that you're trying to order, but at least it's there some element of protection through information. And what you would choose to do, if you look at Companies House and you look at this company, okay, this is a brand name because the domain name does not need to be, or the brand name does not need to be the company name, right? But you find that this is owned by that company. So your ticket is going to be handled by that limited company. And you find the names of the directors and you click on the directors and you realize that this person has been the director of 12 companies that have gone bust in the last 12 years. If you choose to purchase your tickets through that company, then you're taking a risk, but at least you know that you're taking a risk. All this information is helping you make decisions as to whether these people are suitable people to do business with. The Articles of Association, as I said, will give you information about all of this stuff. First of all, whether the company is protected by limited liability and to what extent, about what the directors do, about what the shareholders do, how many shares they are, what rights are attached to those shares, how do the shareholders make decisions, how various admin issues are taken care of, whether the company pays dividends and how the dividends are calculated, all of that stuff. Important stuff both for insiders, people who wish to buy shares in that company, and also people who want to do business with that company. If I told you guys, okay, we're going to set up a company, we need to have the Articles of Association by Monday, let's all brainstorm and sit down and write some Articles of Association. It seems really strange, right? It's like a complex document. This is not easily done, but it should be easily done because companies are supposed to be easy to set up even for people who do not have a legal education. The way it becomes easy is because the statute has default or sample terms and conditions for all of these things. If you look on the website, legislation website, you're going to find those. But if you look at the end of your statute book, if you already got a statute book, it's got what we call model articles of association. And it's got a different model for each type of company, because all companies are not the same. So there's a variety of different types of companies. So you will be able to trace what is model set of articles. If you want to set up your company, you can very easily copy-paste the model set of articles that is relevant to you and go with that. These are capable of amendment subsequently. So you don't even have to think about the details right now. You could go with a model for a private limited company, and if you need to make changes thereafter, then you can make changes following the rules outset in the model as you've got it at the moment. If you're looking for an older company, then you can assume all the problem questions that we do, all the exam papers, assume that the companies we're talking about have been built according to the model articles of association. Unless it specifically says, this company in its articles has got this and this and that, that diverges from the model. Otherwise, you can assume that the model is what it's based on. Just look at the date, because depending on the date of the company, you have different models historically. So if you're looking for a company from the 70s, you need to look for what were the model articles in the 70s. If you're looking for one from yesterday, you look at what is applicable today. Our baseline is always the model articles of association. So you can have a look at those at the end of your statute book and familiarize yourselves with them, because these are things that we necessarily need to come back to. All of this idea of the virtual nature of the company still assumes that there's somebody doing stuff. Even if you have the articles of association telling people how you do that stuff, right? You still need a person to physically do it. So a question becomes as to the performance of corporate acts and who is authorized to perform corporate acts. When somebody represents somebody else, they are an agent. Agents derive their authority either by express provision. I tell you that this lady here represents my textbook selling business. So she can come and do deals with all of you guys to buy your textbooks, but you will be getting them free. The point about agency is that you're dealing with somebody face-to-face perhaps, or there's a contact for you, but the resulting contract is not between you and that person, is with the entity that they represent. So if you're representing me, you can sign deals to sell textbooks to all these kids here, but their contract is with me, it's not with you. Equally, agency in a corporate setting means that you're dealing with somebody who represents the corporate entity. So whatever deal you arrive at, then that deal is with the corporate entity, not with the person there. When you buy your iPhone from the Apple shop, you're obviously not buying the iPhone from the person there. Your contract is with the company. Or if you go to the Vodafone shop and you make you get a contract for your phone, you're not dealing with, George or whomever happens to be sitting there. It's not like George provider that's going to give you the contract. It's Vodafone. So these guys are agent business. In company law, the directors of the company are automatically considered to be the agents. They represent the company to the rest of the world, and you don't need to have anything particular about it. Partners are automatically agents of the entire partnership. If you're talking about people who are not directors of the company, then you need a little bit more information. Can I go to the bike shop and buy 10 bicycles for use of the members of staff and charge the university for it? No, I cannot. Because the fact that you're simply an employee somewhere doesn't mean that you have authority to bind the business into any contracts. If you're a director, yes. If the boss of the place, if the VC goes and buys some bikes, then he can contract on behalf of the university and nobody needs to ask any questions. But if a random employee turns up, just association with the place does not imply that you have this authority. Anybody down the management chain, down from the directors, needs to be specifically authorized. Either they come with a letter that says the university has sent me to buy some bikes, so you can invoice the university directly, or they've done this in the past and this person is known as a representative of the institution. Now, the problems that we've got come from questions about corporate capacity. And this is something that you're going to have to read a little bit carefully on your own. Look, for instance, this. If Yorgos and George are toilet-obsessed inventors, they're directors. There's no question that they represent in relation to third parties. But there is a term in the contract that says they cannot enter into transactions on behalf of the company if the value of the transaction exceeds £100,000. In that case, they need to get approval from the board. The board is all the directors sitting together to make decisions. If Yorgos goes to B&Q and signs a supply agreement for new pipes or whatever, and that has a value exceeding £100,000, what happens to B&Q? Because obviously, if somebody is engaging not as an agent but in their own capacity, then the shop ends up with a contract with that person. But if I go to the bike shop over there and I buy 15, 20 bikes and this costs like £3,000, maybe the shop doesn't want to have a contract with me because maybe I don't have the money. They want to have a contract with the University of Westminster. If they think they're contracting with Westminster, but in fact they end up in a contract with me, that is a significant problem. One of the questions that has come up in terms of corporate capacity and how we understand it is, what happens to the ability of people to represent the company and enter into binding deals with third parties if what they're doing is a violation of the Articles of Association, is a violation of the internal constitution? Now, this has generated quite a lot of case law because, as you can understand, this is a significant problem both for the company. The company doesn't want to end up with contracts with other people because some random guy went and signed everything. Equally, other people, maybe they want to be in business with a company and not with a random person that turned up at the shop. So this has generated case law and a lot of discussion. The answer is provided by statute, and this is in Section 40 of the Companies Act, 2006. Now this explains what happens if we have constitutional limitations in the ability of the people to bind the company in relation to third parties. If you are an authorized representative, either because you're a director of the company or because you are specifically tasked with representing it if you're somewhere in the management chain, any limitation that is internal is not binding to a third party. So it creates a problem internally, but the company still ends up with a contract with a third party. So Yorgos here, if he's a director, he can go and do the contract for 115,000 with B&Q. This would be a valid contract between B&Q and the company, even though this is a violation of the rules internally. Yorgos is going to get in trouble with the others inside the company, but the contract is still valid between the outside party and the company. This is to protect outside people because they're not expected to have the capacity to check all the time. However, if somebody random turns up, then the situation is different. If somebody is not an authorized representative and pretends to do a deal on behalf of the party, then the company could refuse the contract with the external party. This is a discussion built around Section 40 and the case law that has developed around Section 40. Since we're talking about virtual entities, people are entering into contracts with the outside world, needs to be clear-cut. It shouldn't be a question, am I dealing with an agent or am I dealing with a person in front of me? It is very significant and it has very significant consequences for the markets out there.